Hi everyone, thank you for tuning in to another episode of Professors in Conversation. Today we have with us Professor Owen Jones. He has the Weaver Chair in Law, Brain, and Behavior and teaches both law and biology here at Vanderbilt. Professor Jones, thank you so much for being with us today.
Thank you for having me. I'm really glad.
All right, jumping right into it. So, as a professor of both law and biology, you focus on the intersection of law and brain science,
Yes.
which includes neuroscience, how the brain works, and also the evolving evolutionary biology, why the brain has evolved the way that it has. Can you tell me a little bit more about that specifically and the implications of that research in the legal field?
Sure, thank you. People often think about the legal system as it relates to their daily lives, how fast they can drive, whether they can, whether the police can catch a murderer or something like that. But at its broadest, the legal system is really a behavioral intervention in the same way that religion is. Law tries to get you to behave in a way differently than you would behave in the absence of law. Otherwise, we wouldn't need law, right?
That's true.
So that focuses our attention on the need to understand as well as we can where behavior comes from, what affects it, what are its patterns, how can we change it, and that sort of thing. Traditionally, we've always looked to the social sciences for insights on that, which makes great sense. There's a lot of value there. But what I try to do is also add to the conversation at the table what biologists have learned about how the brain works, why it works the way it does, how it leads us to non-randomly associate various sorts of environmental inputs with our behavioral outputs. And so it's all about trying to help the legal system do what we want it to do in a most effective and efficient way. So we're just learning more about where behavior comes from. All comes from the brain, spoiler. So.
It seems like a lot of your work in this area has reflected the law school's newest academic program, the Weaver Program in Law, Brain Sciences, and Behavior. During my time at the law school, you've brought in really incredible speakers to discuss some of these topics during our lunch lecture series. Our students know what this is, but could you tell our audience what is the Weaver Program and what is some of the work that it's done to date?
Sure. So the Weaver Program was gifted to the law school by Ellen Weaver, who's the daughter of the couple, Glenn and Mary Ellen Weaver, in whose name the gift was founded. And Glenn Weaver, Dr. Glenn Weaver, was a leading thinker at the intersection of psychiatry and forensics early on, and always had a lifelong interest in the intersection of law and the brain. And so Vanderbilt was entrusted with this program to try to continue navigating the developments, both empirically, it helps fund some of our brain scanning experiments, for example, and also in education, so outreach to the community through our annual distinguished lectures and that sort of thing.
Amazing. So having all of that information, how does that work and how does that influence lawyers, policymakers? How do we make that tangible in the day-to-day?
Great. As lawyers are zealously trying to represent their clients, whether it's in civil or criminal litigation, they're often bringing new neuroscientific techniques into the courtroom. So one of the things I've done, not only through the Weaver Program, but also through the MacArthur Foundation Research Network on Law and Neuroscience, which I directed for many years, is to try to help the legal system navigate between the wheat and the chaff, basically. Like there's value there, but there's also a lot of ways that you can misunderstand the information, or it can be misused either accidentally or perhaps intentionally by someone unscrupulous. And so what we want to do is try to equip the legal system to understand how these techniques, some of which are frankly would have been considered magic 30 years ago, we want them to understand what the promise is there, what it can do, and also what the peril is in misunderstanding it or going wrong. There are lots more ways to misunderstand something than there are to understand it accurately, and to understand, how to incorporate this into legal thinking, both in litigation and sometimes in legal policy, when you're thinking about how to treat juveniles in a juvenile justice system, for example. The concern is often about how their brains work and how do their brains work differently than adult brains. We've actually done some brain scanning research on that, which helps illuminate the whole question of what's the organism we're dealing with here.
That's fascinating.
Thank you.
You've also conducted significant research on the endowment effect, which is really unique and outside of the traditional realm of legal scholarship. Can you talk about your studies in that area and any key findings that the legal community should know about?
Yes, so sure. I will try to keep it brief. This is an area I really love to talk about.
Good.
So the endowment effect is a name for a single type of cognitive bias. We have many. You've probably heard of anchoring effects and framing effects and these sorts of things. So there are a whole bunch of cognitive biases, and historically those were treated as just individual, unique sort of cognitive quirks of the human brain. The way evolutionary biologists look at it is to say, wow, if the whole species seems to be doing something pretty patterned, maybe it could be just a byproduct of accident, or it could be an evolved adaptation, perhaps bumping up against modern environmental circumstances that lead it to play out in our modern world in unusual ways. Just like moths tend to circle streetlights because they used to navigate by the light and there didn't used to be electricity. So it can lead to this sort of mismatch between the way the brain works and leans us and our new environmental features. So I paired with a primatologist, a wonderful woman named Dr. Sarah Brosnan, and we wound up starting to test this theory with the endowment effect in a variety of primates. We started with chimpanzees. We did several chimpanzee studies and an orangutan study. There were also studies done with gorillas and that sort of thing. And eventually the idea was to create a series of predictions that we could test in these other primates, because if it had an evolved history, it was likely to also be evident in close primate relatives. And then, of course, try to do something new in humans where this theory might lead to some new knowledge. So we were the first to discover and publish a study about the endowment effect in a non-human species. We were then able to make some very well-supported predictions. It turns out that about patterns in which this would be present more or less in chimpanzees. We were even able to turn the endowment effect on and off for chimpanzees and then predict in humans a lot of the variation in the magnitudes of this effect. For those who don't already know the endowment effect, it's fairly technical, but we probably all have some intuitive understanding of it. As a matter of sort of technical description, it's the propensity to value something you have just come to acquire at more, often significantly more, than the maximum you would have paid to acquire it a moment ago. So imagine you, in your mind, you know, isn't posturing, you wouldn't pay more than $5 for this thing on the table. But then you get it. And it turns out in experiment after experiment that people often won't immediately, they won't sell it for often even twice as much, which is weird because if it's worth twice as much to them now, they should have been willing to pay almost twice as much for it a moment ago. The reason this is relevant to law is that the legal system often assumes that goods, and importantly rights to things, services, properties, whatever, entitlement programs, the law assumes that these will tend to flow into the hands of the people who value them most. And so a lot of the legal system is designed to reduce the barriers to trade so that these things wind up where people want them. And in theory, everybody benefits. The problem is if the endowment effect is widespread, then goods don't flow into the hands of people who value them most. They tend more often to get sticky to the hands of people who first get them, because people then immediately start to overvalue them compared to how much they valued it a moment ago. So that's a quirk that drives economists nuts, and it creates inefficiencies in the marketplace, which is why it's relevant to the legal system and why I got interested in it in the first place. But it's been a really fun area of research. I mean, I gotta tell you, working with chimpanzees, they are so smart. and they understand so much. It's really a privilege.
What a phenomenal intersection.
Yes.
That's sensational. Yeah. So we always close out our interviews by talking about what's next.
Yes.
And I know in your case, you just released a book called Force of Nature that's gotten some incredible feedback from some top scholars, including U.S. senators, some best-selling authors, professors, and ambassadors. So congratulations.
Thank you.
So your book explores the everyday implications of natural selection, which you describe, and I quote, overlooked and often misunderstood concept that possesses significant untapped potential. Can you talk about some of the applications you detail in the book and highlight why this is something our legal community could benefit from reading?
Sure. Thank you so much. So many of my colleagues in biology had written books, wonderful books, about how natural selection works, why it's true, that sort of thing. And most people encountered natural selection last, probably in high school biology, maybe for a few days, possibly a week. And what I wanted to do was write a book about why knowing how it works is really concretely useful to the world today, the sorts of things we care about. So I have chapters, for example, on fishing and farming, psychology, economics, engineering, artificial intelligence, medicine, and also law. There are many other fields it's also relevant to, but these are the ones that I tried to give some curated examples that were engaging with just general readers who could then see that the overall arc is this is a process worth understanding, right? So it leads to evolutionary change, but it can, for example, be harnessed in the computer to evolve programs in the same way species evolve. Most people are familiar with large language models now, which are terrific at what they do. But another lesser known field of artificial intelligence called evolutionary computation can take two parent programs that are not very good efforts to solve a problem. For example, NASA used it to design a very particular antenna for a satellite that went into space. And you then recombine the parents, just the way parents do in the biology world, and you can flip ones and zeros to also simulate mutation. And you wind up with a bunch of digital offspring programs. You kill off the least effective, you breed from the most effective, and you do this for thousands of generations in the computer while you go home and have a sandwich and take a nap or whatever, go for a ride. And what you come up with then, after a number of generations, is a simulation of a natural selection process that results in a computer program that was not directly designed by humans, but was evolved to provide a very workable solution to your complex problem. And this has shown to be faster and so more efficient. And in the case of NASA, this program developed a satellite antenna that was not only better at meeting the mission parameters for beam width and bandwidth and what have you, but also was much more energy efficient than what a human team trained to design satellite antennas in a very top-down sort of physics and mathematics way could design. And so it can solve those sorts of problems. But in medicine, it's leading to things like new cancer treatments where you treat cancer not as something that you try to, this is for some types of cancers, not all. You don't necessarily just try to eradicate it, because then you wind up with the antibiotics problem that you drive a superbug, right? The only things that reproduce when you over-apply antibiotics are the bacteria most resistant to that antibiotic. Well, some researchers are now using this in the cancer domain to say, if we try to control the size of the tumor rather than trying to eradicate it, we will better be able to continue using treatment to keep the patient alive, rather than, by our effort to eradicate it, kill off all the easily killed cancer, and then the resistant cancer comes roaring back into the space and eating the resources that the competitive cancer cells that we more easily killed off otherwise would have been consuming. Now, over in the law domain, right? So there are a variety of domains here. Over in the law domain, there are a variety of potential applications I've written about over the years. In the book, I cover just a couple of them. One has to do with the extent to which understanding the effects of natural selection on the brain helps us understand the implications of natural selection for the way we have, as a species, designed legal systems across the globe. We tend to focus on the differences among these, and that's understandable, but the commonalities in legal systems are, I argue, a reflection of the human brain as evolution has designed it, in the same way that the architecture of a beaver dam is a reflection of the beaver brain as natural selection and evolutionary processes have designed it. So it's this external manifestation of the things we tend to care about. And so it's no surprise that, property, reproductive rights, bargains that shows up in, contracts, these sorts of things, bodily assaults and crimes, all of these things tend to be the core features of legal systems around the world. And those core features tend to rank order crimes by severity in very, very similar ways, not only across cultures, but also across, deeper time, going back thousands of years into older legal systems. So one thing that this helps us do is understand the relationship between the evolutionary processes that shape the brain and some features in our legal systems. Obviously, it doesn't define the fine for jaywalking and things like this. But if you look at, say, patterns in how legal systems regulate things that people find disgusting, disgust is one of our most basic evolved emotions. It's why, if I were to ask you to imagine, taking a teaspoon of someone else's coughed up phlegm would make you see, and that's exactly the face that everyone exhibits, right? Your body rejects things that tended to lead to disease conditions, even though the body didn't know what a disease condition is, nor does natural selection. It doesn't have a mind. But we have evolved to avoid things, festering wounds, rotting foods, all sorts of things, and then some sorts of behaviors that people engage in that, like incest, for example, that tend to yield adverse consequences. Now, I don't want to push that so far as to suggest that it, that it defines, large swaths of the legal system, but as an illustration, it tends to lead humans across the globe to reject the same sorts of things. And I think that gives a sense of how that plays out in other domains as well. The second feature in the book that I cover in the law chapter has to do with the ways that we can better understand and better find discrete patterns and behaviors that the legal system is trying to control or to regulate or to even suppress, or sometimes through punishment eradicate. This has to do sometimes with the way there are distinct patterns in humans that weren't otherwise known, that tend to play out in very similar ways, not only with evolutionary theory, how it predicts animal behaviors will result in various predispositions, but also with a lot of observed animal behavior in the context of parent-offspring conflict and child abuse, for example, offspring abuse. And so that can lead you to use your very limited resources in the investigative arena to try to target circumstances that are more likely to wind up with abusive situations. So I know that sounds very general at this
that's why we have to read the
level
book.
of conversation, but it's a very exciting literature, and it's so often that when we look at patterns of animal behavior, we find things that can illuminate the way we think about how the human animal behaves. Now, I hasten to add, this does not at all mean that justifies any behavior or excuses it. Not at all. Yeah. There's no way to get there from any fact scientifically. But my view is the better you understand the facts, the better equipped you are to try to do whatever it is you're trying to do in a democratically percolated legal process. So, the legal system, through our values, defines what we're trying to achieve. And what I've tried to do is show how sometimes, not always, but sometimes having a better understanding of how the human brain works biologically and how it came to work that way can inform the ways we try to achieve what we're trying to achieve.
Fantastic. Thank you for your time today and for taking the time to educate us on the intersections of neuroscience and the law. And thank you so much for tuning in for another episode of Professors in Conversation. If you want to see more of these, subscribe to our YouTube channel. If you want to see other student-led content, you could definitely follow us on TikTok and Instagram, and we'll see you next time.
Thank you so much.